Hello everyone, welcome back to part 3 of our series on the Negotiable Instrument Act 1881. Before moving to today's important provisions, let us do a quick recap of previous two classes. So in part 1, we have discussed the important definitions from section 4 to 10, which is provided under the chapter 2 of the Negotiable Instrument Act. So the section 4 is about promissory note, 5 is bill of exchange, 6 is check. You should never forget these sections. And then we saw the parties to the instrument, that is drawer, drawee, draw in case of need, acceptor, acceptor for honor, and payee. Then holder, 9 is holder in due course. So connected to it, section 10 is payment in due course. Then 11, 12 is inland instrument and foreign instrument. Then 13, 14 is connected negotiable instruments and negotiation. Section 15 is about endorsement and section 16 is the types of the endorsement, that is endorsement in blank and endorsement in full. Then section 17 ambiguous instrument, section 18 where amount is stated differently in figures and words, and section 19 instruments payable on demand. Section 20 is about inchoate stamped instruments, and section 21 defines at sight and on presentment, and section 22 is about maturity and the days of grace. In today's video, we are going to see other important provisions which may be expected to be coming for the examination. The first section is section 99, which is noting. So what is noting? When a promissory note or bill of exchange has been dishonored by non-acceptance or non-payment, the holder may cause such dishonor to be noted by a notary public. So the noting by the notary public is provided as noting under the section 99, and this noting can be made upon the instrument or upon a paper attached thereto, or partly upon the instrument and partly apart upon the paper attached thereto. Okay, so this is about noting. And then what is protest about? When a promissory note or bill of exchange has been dishonored by a non-acceptance or non-payment, the holder may, within a reasonable time, cause such dishonor to be noted and certified by a notary public. So noting will be done as per section 99, and after that, if it is certified, that is called, that such a certificate is called to be the protest. Okay, then there is another concept called protest for better security. This happens when the acceptor of a bill of exchange has become insolvent or his credit has become publicly impeached before the maturity of the bill. Then the holder may within a reasonable time cause a notary public to demand better security of the acceptor, and on its being refused within a reasonable time cause such facts to be noted and certified as aforesaid. So such certificate is called the protest for better security. That means in case before the maturity date that is mentioned on the bill, the acceptor has become insolvent, means the holder will have another option, that is through the notary public he can demand for better security. Okay, so in case even after demanding for the better security it was refused, he can get it noted as provided under section 99 and also make a certificate as per section 100. Then that certificate is called as the protest for better security. Okay, clear with it? Then coming to the next very important provision with regard to negotiable instruments is section 118, that is the presumption. So the following presumptions shall be made. There are 7 presumptions which is provided under this section, and particularly UGC net loves to ask questions in a chronological order. So you have to study all these 7 presumptions in a order as provided under the Bar Act. Okay, so the first presumption is of consideration. So the presumption is that if a negotiable instrument is drawn to a person, it is presumed that it is drawn for a consideration. Okay, then the second presumption is that if the negotiable instrument contains a date, then it is presumed that on that date the negotiable instrument was made or drawn. Okay, then this third clause, that is C clause, is that as to time of acceptance, and it is stated that every accepted bill of exchange was presumed to be accepted within the reasonable time after its date and before its maturity. Okay, that is after the date that is mentioned on the negotiable instrument and before the maturity date it was accepted, like that it will be presumed. And then D is as to time of transfer. So every transfer of negotiable instrument will be presumed that it was transferred before the date of maturity. And as to order of endorsement, it is presumed that the endorsements were made in the order in which they appear on then. Okay, it is appeared on the negotiable instrument. In that order, it was like transferred from one person to another through endorsement. And then as to stamp, so every negotiable instrument is presumed to be duly stamped, and then the holder is a holder in due course. This is also a presumption. Okay, so the first presumption is of consideration, the second one is as to the date and as to the time of acceptance and as to the time of transfer, and then as to the order of endorsement and as to properly duly stamped and that the holder is the holder of due course. Fine. Then moving on to the next very important part is chapter 17 of the negotiable instrument. And the section is section 138, which deals with the dishonor of check. So, what is dishonor of check? It is stated that if the check is returned by the bank unpaid, that is said to be the dishonor of check. And for what reasons it can be dishonored is it is stated that if the amount in the account is insufficient to honor the check, then it is said to be the dishonor. And or else if it exceeds the amount arranged to be paid, then it is also said to be the dishonor of check. So there are various other reasons for dishonor, but these two reasons are particularly explicitly provided in the provision itself. And for this, the punishment is provided as imprisonment for a term which may extend to 2 years, and also fine which may extend to twice the amount of check. So this you have to be very clear. Also, you have to know about this proviso, that is the check has to be presented to the bank within a period of 6 months from the date on which it was drawn, or within the period of its validity, whichever is earlier. Okay, or else it cannot be said to be the dishonor. Okay, so you have to present the check before a period of 6 months from the date on which it was drawn, that is the date on which it was made. Okay, then moving on to the next important provision, section 139, which is presumption in favor of the holder. So apart from the 118, section 118, which provides for 7 presumption, section 139 is also very important. It states that it shall be presumed, unless the contrary is proved, that the holder of a check received the check of the nature referred to in section 138 for the discharge in whole or in part or of any debt or other liability. So only for some debt or for some liability only he have given his check, like that it will be presumed. Then section 140 is about the defense which may not be allowed in any prosecution under the section 138. It says that it shall not be a defense in a prosecution for an offence under section 138 that the drawer had no reason to believe when he issued the check that the check may be dishonored or present on presentment for the reasons stated in that section. So we already know that ignorance of law is never excused. So like that, the section 140 says that you cannot take a defense that you don't know it will get dishonored on presentment. Okay, then the other important sections, just go through this by the short title, that is enough. So section 141 provides for the offences by the companies, and section 142 cognizance of the offences, and 143 is power of the court to try these cases summarily, and 143A is about power to direct interim compensation. That's it for today. Thanks for watching the video. In case if you found this video helpful, please subscribe to the channel and give a like. Thank you.